in striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch. The Supreme Court has stopped the presidency itself. That's what they've done. And really, it's been an amazing period of time this last hour. There are people elated all over the country. I've seen such happiness and spirit. Sometimes you don't see that, but this case is very important. I was elected on a historic mandate, but in recent months we've seen a handful of radical left judges effective.
The ruling came down in a case that had been working its way through the federal courts since 2024, the landmark matter known as Trump versus United States. The central question before the justices was straightforward yet profoundly consequential for the future of American democracy. Does a president enjoy immunity from criminal prosecution for actions taken while in office? Trump's legal team had argued aggressively for absolute immunity, insisting that once a person assumes the presidency, every decision, every statement, every directive, whether official or unofficial, falls under an unbreakable shield of protection that lasts forever. They contended that subjecting a former president to prosecution would paralyze the executive branch, making it impossible for future leaders to act decisively without fear of endless legal harassment after leaving office. The government's position was equally firm but far more measured. Presidents are not kings, they maintained. While certain core constitutional functions might warrant limited protections, there could be no blanket immunity that places any individual above the law. Once out of office, a president must answer for alleged crimes just like any other citizen, ensuring accountability remains a cornerstone of the republic. In a decisive 6-3 ruling, the Supreme Court sided squarely with the government. The majority opinion made clear that Donald Trump does not possess absolute immunity. Only the most fundamental presidential powers, such as issuing pardons or exercising command over the military in genuine national security contexts, receive strong presumptive protections that are difficult to overcome. Everything else, from political maneuvering to personal conduct, remains fair game for prosecution if evidence of criminality exists. This decision stands as one of the most significant constitutional pronouncements in modern American history, reshaping the boundaries of executive power and reaffirming that no one, not even a former commander-in-chief, stands beyond the reach of justice. The implications of this ruling ripple outward in multiple directions, touching every aspect of the ongoing legal battles surrounding Trump. First and foremost, it unblocks all the major criminal cases that had been stalled pending clarification on immunity. The January 6th related prosecution centered on allegations of election interference and efforts to subvert the certification of electoral votes can now proceed without further obstruction. Prosecutors have meticulously gathered evidence of communications with state officials, coordination around alternate elector slates, and public statements designed to pressure lawmakers and rally supporters toward disruptive action at the Capitol. With immunity claims dismissed, those threads can be woven into a coherent narrative for a jury to evaluate. Similarly, the classified documents case moves forward at full speed. Trump stands accused of removing hundreds of sensitive materials from the White House upon departure, storing them haphazardly at Mar-a-Lago, resisting subpoenas, and misleading investigators about their existence and handling. His defense had leaned heavily on the notion that declassification authority provided cover, but the court rejected that extension, noting that post-presidency conduct and obstructive acts fall outside any official shield. Obstruction of justice charges, including allegations of evidence destruction and witness tampering, also gain new momentum. These involve claims that Trump directed staff to delete or conceal records, including sensitive files tied to various controversies, and used intermediaries to obscure the truth from federal authorities. Grand juries had already been impaneled, witnesses prepared, and discovery materials organized. The only barrier had been the immunity question. Now that barrier has crumbled, and trials could begin within weeks rather than months, injecting unprecedented drama into the political calendar. This outcome completely dismantles Trump's long-standing legal strategy of delay and deflection. For years, his approach relied on procedural maneuvers, appeals, and claims of presidential privilege to push back court dates past critical electoral milestones. The hope was that winning or maintaining political leverage would eventually force prosecutors to hesitate or drop charges under public pressure. Central to that plan was faith in a conservative Supreme Court majority, including justices appointed during his own term, to deliver a favorable outcome. Yet even those appointees joined the majority in rejecting absolute immunity. This bipartisan judicial consensus, spanning ideological lines, leaves Trump with no remaining avenues for delay on constitutional grounds. Appeals on other issues may linger, but the core shield he sought has been stripped away, forcing his legal team into a defensive posture they had desperately hoped to avoid. The timing could not be more damaging. We find ourselves in April 2026, with midterm elections looming just 7 months away. Trump already faces a torrent of overlapping scandals that have eroded his public standing. Revelations from the Epstein files have drawn intense scrutiny, with his name appearing extensively in newly unsealed documents that raise uncomfortable questions about past associations and interactions. A high-profile lawyer once close to his inner circle has turned state's evidence, providing prosecutors with detailed insider accounts, documents, and recordings that paint a vivid picture of decision-making processes inside the administration and beyond. Public moments such as an awkward debate appearance where Trump appeared disengaged and ultimately walked off stage have gone viral, fueling speculation about his stamina and mental sharpness. Reports of slurred speeches at rallies have circulated widely, prompting concerns from even some supporters about fitness for leadership. Controversies involving comments on fallen soldiers have further alienated military families and veterans, highlighting what critics describe as a pattern of callousness. Layering criminal trials on top of this existing chaos ensures that legal proceedings will dominate news cycles through November. Every campaign stop, every interview, every policy discussion will be overshadowed by questions about impending court dates, witness testimonies, and potential verdicts. The political toll is difficult to overstate as voters are reminded daily of the legal clouds hanging over the former president. Trump's immediate reaction was characteristic, unleashing a series of furious posts on Truth Social written in all capital letters. He decried the Supreme Court for ransacking the nation, labeled the justices disloyal, and called the decision the worst in American history. He singled out Chief Justice Roberts by name and turned on the conservative justices he himself had elevated, accusing them of betraying conservatism and acting as traitors to the cause. His most ardent supporters quickly amplified these sentiments, flooding social media with claims that the court had sold out and that even Trump's own appointees had turned against him. Yet this narrative of betrayal rings hollow when examined closely. The justices did not invent new law or pursue a partisan agenda. They interpreted the Constitution based on long-standing principles that no person, regardless of past office, enjoys perpetual exemption from criminal accountability. The idea that presidents are not above the law is not radical. It is foundational to the American system, rooted in the rejection of monarchical privileges that the framers explicitly sought to avoid. Beyond Trump's personal circumstances, the ruling establishes vital precedent for future presidents and the broader framework of executive power. It draws clear distinctions: absolute immunity for a narrow set of core constitutional duties where judicial interference could undermine national functions, presumptive immunity for other official acts that can be rebutted with evidence of criminal intent, and no immunity whatsoever for purely private conduct. This three-tiered approach prevents abuse while preserving the ability of executives to govern effectively. For decades, scholars and practitioners had debated whether a former president could face prosecution. The Supreme Court has now provided a resounding affirmative answer. Yes, accountability is possible, and when crimes are proven necessary. This clarification strengthens the rule of law by closing loopholes that could have allowed future leaders to commit wrongdoing with impunity, secure in the knowledge that leaving office would erase all consequences. For Trump himself, the decision marks the beginning of what many legal observers describe as the endgame. The cases against him feature substantial evidence, much of it already in the public domain. His former lawyer's cooperation has delivered a trove of corroborating materials. Viral footage from rallies and interviews provides contemporaneous context that prosecutors can use to demonstrate intent. With immunity removed, these elements can be presented directly to juries without endless preliminary litigation. If convictions follow, as many analysts predict given the strength of the documented record, the consequences extend far beyond fines or probation. Prison time becomes a realistic possibility for serious felonies involving obstruction and conspiracy. Even short of incarceration, a felony conviction would impose lifelong restrictions, loss of security clearances, barriers to certain business activities, and profound damage to any future political viability. Trump's increasingly erratic public statements and posts suggest he recognizes the gravity of the moment, as the walls of legal accountability close in with no escape hatch remaining. Delving deeper into the legal reasoning behind the ruling reveals why it proves so devastating. The case originated in 2024 following indictments tied to January 6th events. Trump's lawyers filed sweeping immunity motions at every level. District courts rejected them. Appellate panels upheld those rejections. And now the highest court in the land has done the same. The majority carefully parsed presidential powers. Core functions like pardon authority or military directives receive robust protection because they lie at the heart of executive responsibility and involve decisions where second-guessing by courts could harm national interests. But pressuring officials to alter election results, organizing shadow elector schemes, or inciting crowds to disrupt constitutional processes do not qualify as core powers. Such actions fall into the presumptive category at best, and prosecutors can overcome that presumption by demonstrating they were undertaken for personal or partisan gain, rather than legitimate governmental purposes. In the documents matter, post-presidency retention and concealment efforts receive no protection at all, as they occurred after official authority had ended. Obstruction charges similarly involve conduct that no reasonable interpretation of presidential duty could encompass. Destroying evidence or directing cover-ups contradicts the president's oath to faithfully execute the laws. The 6-3 vote carries additional weight because it was not a narrow partisan split. Conservative justices appointed by Trump joined liberals in the majority, underscoring that the outcome transcended ideology. Chief Justice Roberts authored the opinion, emphasizing institutional integrity. Only a small minority dissented, and even they stopped short of endorsing blanket immunity, preferring instead slightly different calibrations around official versus unofficial acts. Legal experts across the spectrum have praised the decision as a historic affirmation of accountability. Former prosecutors note it clears logistical hurdles for trials to commence promptly. Constitutional scholars highlight its role in resolving long-standing ambiguities. Even some conservative commentators who align with Trump's policy views acknowledge that shielding crimes would undermine the very principles conservatives claim to champion. The consensus view holds that Trump's defenses have collapsed, leaving conviction as a probable outcome when evidence is laid before impartial juries. Politically, the fallout promises to reshape the landscape heading into midterms. Republican candidates at all levels now confront uncomfortable questions. Will they continue supporting a figure facing active criminal prosecution? Should he step aside to allow the party to move forward? How do they reconcile backing someone potentially convicted of felonies with commitments to law and order? These queries leave little room for comfortable answers. Defending Trump risks alienating independent and moderate voters who prioritize institutional norms. Criticizing him invites backlash from the base. Many are opting for evasion, claiming they need more time to review details, but with trials unfolding in real time, such dodges will prove unsustainable. Courtroom testimony, dramatic evidence presentations, and daily headlines will keep the story alive, forcing continuous engagement. Democrats, meanwhile, are already capitalizing. Campaign advertisements feature excerpts from the ruling, framing it as validation of their long-held warnings about accountability. They pose direct questions to voters. Do you want leaders who believe themselves above the law? This messaging resonates with broad swaths of the electorate, tired of chaos and eager for stability. The interconnected nature of Trump's scandals amplifies the damage. Epstein-related documents intersect with themes of personal conduct and judgment. The cooperating lawyer provides context linking various episodes. Public gaffes illustrate fitness concerns that juries may weigh when evaluating intent or credibility. Each element reinforces the others, creating a cumulative portrait of a leader whose actions consistently prioritize self-interest over institutional duty. This convergence suggests not isolated missteps but a pattern, making defense arguments more challenging. Looking ahead, the trial schedule accelerates the pressure. Judges have moved swiftly post-ruling, setting jury selection timelines that place opening statements in the heart of campaign season. Trump will sit in courtrooms as a defendant while his party fights for congressional majorities. The optics could hardly be worse. Daily reminders of alleged wrongdoing coinciding with voter outreach. Prosecutors' evidence includes public records, private communications, and insider accounts now fully admissible. Juries will hear Trump's own words played back, see documents bearing his signature or instructions, and listen to witnesses who once served loyally but chose truth over allegiance. Defenses centered on witch hunts or deep state conspiracies hold little sway in evidentiary proceedings where facts, not rhetoric, decide outcomes. This moment represents a watershed for American governance. For years, questions lingered about whether the system could truly hold powerful figures accountable. The Supreme Court has answered by removing artificial barriers and allowing the judicial process to run its course. Trump faces the same system every citizen encounters, with the same rights to defense but also the same obligation to answer charges. Whether convictions ultimately follow, whether sentences include incarceration, and whether his political influence survives remain to be seen. Appeals will continue and political dynamics may shift, yet the process itself signals that constitutional guardrails function even under intense pressure. The rule of law, often tested but never fully broken, receives reinforcement at a critical juncture. As the country absorbs these developments, attention turns to practical consequences across domains. Legally, multiple venues prepare for concurrent or sequential proceedings, each building on the others. Politically, party strategists recalibrate messaging and candidate recruitment, anticipating a post-ruling environment where Trump's dominance faces genuine challenge. Internationally, allies monitor stability while adversaries assess opportunities arising from domestic distraction. Socially, public discourse intensifies around themes of accountability, leadership standards, and democratic resilience. Through it all, the central figure remains Donald Trump, navigating what many describe as the most perilous chapter of his public life. Expanding on the legal framework further illuminates its robustness. The court meticulously avoided creating a roadmap for unchecked executive overreach. By limiting absolute immunity to enumerated core powers, it preserved flexibility for legitimate governance while closing doors to criminal exploitation. Presumptive immunity requires prosecutors to demonstrate that acts were unofficial or undertaken with corrupt motive, a standard that balances protection with accountability. Private acts receive zero shelter, ensuring personal misconduct cannot hide behind official title. Applied to Trump's cases, this framework exposes vulnerabilities across the board. January 6 conduct involved private political objectives rather than official duties. Document handling after leaving office lacked any presidential character. Obstructive efforts contradicted public responsibility. Each category fits neatly into the court's analysis, leaving scant room for reversal. Reactions from the broader legal community reinforce the ruling's soundness. Bar associations, academic institutions, and retired judges have issued statements praising its clarity and restraint. They note that without such boundaries, the presidency could evolve into an office insulated from consequence, eroding separation of powers. Public polling in the immediate aftermath shows mixed but informative trends. Majorities across parties affirm that no one should be above the law, even as partisan divides persist on specific applications. This underlying consensus provides fertile ground for the trials to proceed with perceived legitimacy. Trump's personal trajectory in this environment appears increasingly constrained. Long accustomed to controlling narratives through media dominance and loyal followings, he now contends with institutional forces less susceptible to pressure. Court rules limit public commentary that could prejudice proceedings, adding another layer of frustration. Financial strains from legal fees compound existing pressures, while donor enthusiasm may wane amid uncertainty. Family and close advisors face their own decisions about loyalty versus self-preservation as cooperation deals proliferate. The psychological toll manifests in heightened rhetoric and visible strain during appearances, further feeding cycles of negative coverage. For the Republican Party, the ruling forces a reckoning with dependency on a polarizing figure. Decades of institutional norms clash with recent populist shifts. Younger leaders eye opportunities to redefine the brand, emphasizing policy substance over personality cults. Internal discussions, though discreet, increasingly contemplate scenarios where Trump steps back, voluntarily or otherwise, allowing fresh voices to emerge. Midterm success or failure will hinge partly on how effectively the party manages this tension, distancing where necessary without alienating core voters. Historical precedents suggest parties can recover from scandals, but the scale here, involving active prosecutions of a recent standard-bearer, tests those limits. Democrats view the development as validation after years of investigations and impeachments. Their messaging focuses on restoration of norms, warning that unchecked power threatens all citizens regardless of affiliation. By highlighting the conservative court's role, they blunt accusations of partisanship, framing the outcome as objective justice. Voter mobilization efforts center on turnout in key districts, leveraging courtroom drama to illustrate stakes. Independent analysts project significant impacts on down-ballot races, with some forecasting shifts in suburban and moderate areas sensitive to governance issues. Globally, the spectacle invites commentary on American exceptionalism. Democratic partners express hope that accountability mechanisms endure, while autocratic regimes highlight divisions as evidence of decline. Foreign policy execution grows complicated when leadership credibility faces domestic assault. Military alliances, trade negotiations, and security commitments require steady hands. Uncertainty introduces friction. Observers note that while the United States has weathered crises before, the intersection of legal, political, and personal elements creates unique volatility.